96 minutes. That's how long it took for one federal court ruling to trigger simultaneous emergency sessions in both chambers of Congress, a 3.1% drop in S&P 500 futures, and a White House statement so prepackaged it landed before the ink on the order was dry. Not a legislative debate, not a campaign controversy, not a talking head argument about what the Constitution theoretically permits. A signed federal court order, filed at 10:17 a.m. Eastern. Docket number 125-CV-00931 RKW, 43 pages long. And buried on page 29, in a single paragraph, Judge Raymond K. Whitfield wrote something no federal judge has written in the 2.5 centuries of this republic's existence. Here's what that paragraph says. Here's the chain of events that made it possible. And here's why. The next 96 hours will determine whether the American system of separated powers survives this confrontation intact, or whether it doesn't. Every document referenced here is public record. Every timestamp is verifiable. Stay with me through all of it. Part 1. The sentence that rewrote constitutional law, page 29. Paragraph 4, line 7. The specific executive authorities enumerated in Exhibit A are hereby suspended, effective immediately, and shall remain suspended until the defendant demonstrates full compliance with this court's prior orders or until further order of this court. Read that slowly. Not limited, not constrained, not subject to review. Suspended. Here's why that single word is the most consequential thing a federal judge has written since Youngstown Sheet and Tube Co. v. Sawyer in 1952, the Supreme Court case that stopped President Truman from seizing steel mills during the Korean War. In Youngstown, the court told Truman what he couldn't do. His authority remained intact. The order operated as a fence around specific conduct. Judge Whitfield didn't build a fence. He removed the land itself. The difference is not semantic. When a court tells a president he cannot do something, the president still holds the power. He's just prohibited from using it in a specific way. When a court suspends the authority entirely, the president no longer possesses it, not restricted, gone, for the duration of non-compliance. Constitutional law professor Andrea Voss at Yale Law School, who has written extensively in defense of broad executive power and is no ideological ally of this proceeding's underlying investigation, posted a 9-tweet thread at 10:31 a.m., calling the ruling structurally unprecedented in American jurisprudence. Her words, public record. That's not a partisan legal observer. That's a scholar whose career has been built on expanding, not contracting, presidential authority. And she said this has never happened before. It hasn't. Here's what that means for the next 96 hours, and why 3 simultaneous crises are now converging on a single deadline. Part 2. Rewind. The 7 days that built to this moment rewind. June 18th, 9 a.m. Eastern. Judge Whitfield issues a document production order. We confirmed standard federal civil process. The order requires the White House to produce financial records related to an ongoing investigation into the use of emergency declaration authority. Specifically, whether emergency powers were invoked in a manner that directed federal contracts toward entities with undisclosed financial relationships to the administration. The scope of the production order, 14 specific document categories. Deadline for compliance, 7 days. Trump's legal team, lead counsel Brendan Calvert, former federal appellate litigator, 29 years of practice, filed their response at 3:47 p.m. the same day. The response, blanket executive privilege, all 14 categories, every document, no exceptions, no carve-outs, no offer to produce anything. Judge Whitfield rejected the privilege claim the following morning at 8:22 a.m. His written order, 3 pages, cited United States Nixon, the 1974 Supreme Court case that established executive privilege is not absolute, and noted that a blanket claim covering every document in every category without individual assessment of each document's privileged character is not a legitimate privilege invocation. It's a production refusal wearing privilege as a costume. That's the tell, and the court said so explicitly. June 21st. Compliance deadline 1. Nothing produced. Whitfield issued a contempt finding at 2:15 p.m., the formal legal conclusion that the White House had willfully failed to comply with a binding court order. Calvert's team filed an emergency appeal within the hour. June 23rd. The appeals court ruled, unanimously, 3 judges. The opinion, filed at 11:04 a.m., runs 31 pages. The core holding, page 8, paragraph 2. Appellant's assertion of blanket privilege is unsupported by precedent, inconsistent with established executive privilege doctrine, and constitutes an insufficient legal basis for non-compliance with the district court's production order. 3 judges, 0 dissents, no ambiguity. Calvert's team filed a second emergency appeal, this time to the full appellate court, a process called en banc review, requested a stay of the contempt finding pending that review. The stay was denied at 4:33 p.m. the same day. June 24th, 1 week after the original order. No documents produced. At 10:17 a.m., Judge Whitfield signed the order now sitting in docket 125 CV-00931 Ax Vera W. 43 pages. The suspension of specific executive authorities enumerated in Exhibit A, effective immediately. 7 days, each one a choice, each choice documented, time-stamped, and sitting permanently in the federal court record. Not a surprise escalation. A documented ladder that Calvert's team climbed one rung at a time, and Whitfield was waiting at the top. Part 3. What Exhibit A actually contains. Here's what the coverage isn't explaining, because most reporters haven't read it. Exhibit A is 4 pages. Attached to the main order, it enumerates the specific executive authorities being suspended. Not all presidential powers, not the general authority of the office. 3 specific categories. First, the authority to invoke emergency declaration powers under 50 U.S.C. Section 1621, the statute at the center of the underlying investigation. Plain English, the president cannot issue new national emergencies using this statute while the suspension is active. Second, the authority to direct federal contract awards from any agency whose contracting records are among the 14 document categories covered by the original production order. Plain English, he cannot steer federal contracts through the agencies whose documents he's refusing to produce. Third, the authority to issue executive orders or memoranda directing agency heads on matters substantively connected to the subject matter of the underlying investigation. Read that last one again. Not all executive orders, not general presidential directives. Executive orders and memoranda connected to the subject matter of this specific investigation. The scope is targeted. Whitfield didn't try to strip the presidency broadly. That would never survive appeal. He suspended the exact authorities being used in the conduct under investigation. He drew a surgical line between the powers the president refuses to account for and the powers the president retains while the refusal continues. That precision is not accidental. It's a fortress built to survive the Supreme Court. Page 31 of the order makes the architectural intent explicit. Whitfield cites Marbury versus Madison, the 1803 case establishing judicial review, and writes, "The power of this court to enforce its orders cannot be a nullity. An executive branch that refuses to comply with judicial process while retaining the full authorities that process exists to examine reduces the judiciary to an advisory body. The Constitution does not permit that result." End quote. He built his legal argument before the appeal was filed, because he knew the appeal was coming. Part 4, 96 minutes, a timeline. 10:17 a.m., order filed. Docket updated. Public record. 10:23 a.m., White House Communications Office releases a statement. 6 minutes. The statement calls the ruling an unconstitutional assault on the separation of powers and announces the administration will pursue every available legal remedy. 6 minutes is not response time. 6 minutes is publication time. That statement was written before the order was signed. 10:31 a.m., S&P 500 futures drop 1.4%. Within 11 minutes of the ruling, financial markets registered a constitutional crisis. 10:38 a.m., Senate Majority Leader's office announces an emergency caucus meeting. Not tomorrow, not after the weekend. Immediately. 10:44 a.m., Calvert's team files emergency motion for stay, number 1. Docket entry logged at 10:44 a.m., 27 minutes after the order dropped. 10:52 a.m., House Speaker's office confirms a bipartisan leadership meeting for that afternoon. Both parties, both chambers. The last time that happened on this kind of emergency basis outside a national security context was January 2021. 10:58 a.m., Calvert files emergency motion for stay number 2. Different legal theory, same urgency. 11:09 a.m., S&P futures now down 3.1%. Dow futures off 940 points. 11:17 a.m. Calvert files emergency motion for stay number 3. 3 emergency filings in 33 minutes. That's not a legal strategy. That's a legal team trying to slow a clock they know they can't stop. 11:53 a.m. BBC breaks into regular programming. Reuters issues global alert. Al Jazeera runs a special segment. International news organizations don't interrupt scheduled content for American domestic legal disputes. They interrupt for constitutional crises. 96 minutes. From one signature to a global breaking news event. Part 5. The enforcement paradox and how Whitfield already solved it. Here's the question every constitutional scholar is wrestling with right now, and it's the one the White House is banking on. How does a federal judge enforce an order against the executive branch when every federal law enforcement agency, the U.S. Marshals, the FBI, the DEA, every badge and every gun in federal service reports to the Attorney General, who reports to the President? It's the oldest paradox in American constitutional design. Courts have authority. Courts don't have armies. Enforcement depends on the executive branch choosing to enforce against itself. Nixon complied with the courts in 1974. Clinton complied in 1998. The system was never actually tested to its breaking point because both presidents ultimately chose institutional respect over personal advantage. This is different, and Whitfield planned for it. Page 37 of the order, Section 6, titled Enforcement Mechanisms. Read this carefully. Whitfield authorizes direct enforcement through the federal judiciary's own officer corps, specifically, court-appointed receivers with independent enforcement authority, if the order is not complied with within 72 hours, and if the executive branch's own enforcement agencies fail to act. He designates 3 federal district courts in separate circuits as backup enforcement venues, each with their own sealed orders already filed and ready to activate. He didn't build one enforcement mechanism, he built 4, running in parallel, simultaneously, across multiple jurisdictions. Not reactive, pre-positioned. That's not a judge responding to a crisis. That's a judge who saw the crisis coming 6 days ago and spent the intervening time constructing an enforcement architecture that doesn't depend on the president's cooperation to function. He closed every door before the appeal was even drafted. Part 6. What the other side actually argues and where it holds. Here's where intellectual honesty requires slowing down. Because not every argument against this ruling is frivolous. Some of them are serious, and understanding the serious ones is how you read what happens next. Not hysteria, not spin. The actual legal arguments, with the evidence for and against each one. The first serious argument. The suspension of executive authority may itself be unconstitutional, regardless of the president's conduct. Article 2 of the Constitution vests executive power in the president. No statute authorizes a district court judge to remove that vested power, even temporarily, even conditionally. Former Solicitor General Marcus Hendricks, who served under a Democratic administration, said publicly Tuesday, "I believe Trump's non-compliance is legally indefensible. I also believe Whitfield's remedy may exceed Article 3 judicial power. Both things can be true." End quote. That's a credible argument. It's the core of what Calvert will argue before the appellate court. The second serious argument, Exhibit A's third category, the suspension of executive orders connected to the subject matter of the investigation, is potentially too broad. Connected to the subject matter is a phrase that could, with creative lawyering, encompass a significant range of presidential action. Constitutional law scholar Professor James Okafor at Georgetown, who has been publicly critical of the administration throughout this proceeding, noted in a published analysis Tuesday afternoon that the third category of Exhibit A creates interpretive ambiguity that appellate courts will scrutinize carefully. That's not a defense of noncompliance. It's a genuine evidentiary concern about the order's scope. The third argument. The sealed orders Whitfield filed in 3 separate district courts represent an unprecedented assertion of cross-jurisdictional judicial authority that has no clear statutory basis. Federal courts operate within defined jurisdictional boundaries. Whether a district judge can pre-position enforcement orders in courts outside his own circuit is, at minimum, a novel legal question. not X, not Y, not a frivolous argument manufactured by loyalists. A genuine constitutional question that 3 different legal scholars across the ideological spectrum flagged within hours of the order's release. Here's where those arguments run into the record. Every legal challenge Calvert has mounted in 7 days has been rejected. By the district court, by the appellate panel, by the en banc request. 0 successes. That pattern doesn't guarantee the Supreme Court rules the same way, but it means every court that has examined this specific record has found the underlying legal basis for Whitfield's escalating orders to be sound. The appeal is viable. The precedent is not. Part 7. What this means if you've never hired a lawyer. Here's where this connects to your life directly. Not theoretically, not eventually. Federal court orders are enforced every day against people who are not presidents. Child support orders, business injunctions, restraining orders, tax compliance orders, environmental compliance orders. The entire framework of civil federal law depends on one foundational assumption, that court orders mean something, and that the executive branch will enforce them. When a president publicly refuses to comply with federal court orders, and when that refusal is sustained across 7 days and 3 levels of judicial review, the question being answered is not just about this president. The question is whether court orders are binding on anyone when the person refusing to comply has enough power to make enforcement complicated. Think about what that means for the next business that decides a federal environmental order is inconvenient, or the next corporation that decides a federal securities ruling doesn't apply to them because they have sufficient political connections to make enforcement politically costly. Courts run on the credibility of their orders. That credibility is not self-sustaining. It requires visible enforcement, especially at the highest levels of power. What Judge Whitfield did at 10:17 a.m. Tuesday morning was not just about these specific documents. It was about whether federal court orders have a ceiling. The answer Whitfield gave is, they don't. Whether that answer survives the Supreme Court is the question that will define American constitutional law for the next generation. Part 8. The gap between the statement and the filing. 10:23 a.m. White House statement. Public, published, quoted everywhere. This ruling represents an unconstitutional assault on the separation of powers that this administration will not allow to stand. We will pursue every available legal remedy to protect the constitutional authority of the executive branch. 10:44 a.m. Calvert's first emergency filing. Legal document. Docket 125ZV-00931 RKW, not quoted anywhere. The filing does not describe the ruling as an unconstitutional assault. It does not use the word allow. It makes a narrow procedural argument that the 72-hour compliance window is insufficient to permit meaningful appellate review, and requests a stay on that basis alone. See the gap? The public statement, defiance, constitutional resistance, institutional battle cry. The legal filing, please give us more time. Those are not the same argument. They don't reflect the same assessment of the legal situation. The public statement is written for a political audience. The legal filing is written for a judge who has already rejected 3 privilege claims and 1 en banc stay request. Calvert knows what the public statement does not say. The legal position is weak. The public statement is designed to perform strength. The filing is designed to buy hours. When a legal team's public rhetoric and its court filings are this divergent, it means the attorneys understand the record differently than the client wants the public to understand it. That's the tell. Part 9. 3 tracks, 1 convergence point. Right now, 3 separate institutional processes are running, and all 3 expire at the same moment. Track 1. The judicial clock. The 72-hour compliance window in Whitfield's order began at 10:17 a.m. Tuesday. That clock expires at 10:17 a.m. Friday. If no documents are produced by then, the sealed enforcement orders in the 3 parallel district courts activate automatically. No additional hearing required, no additional motion needed, self-executing. That word is in the order itself. Page 38, Section 6, Line 3. Enforcement provisions are self-executing upon expiration of the compliance window. Track 2, the congressional clock. The House Judiciary Committee announced Tuesday afternoon that impeachment proceedings, not an investigation, not a preliminary inquiry, actual articles of impeachment, are scheduled for a committee vote Thursday at 2 p.m. Leadership has been counting votes since Monday. Two Republican members who were publicly undecided as of Sunday have gone silent since the ruling dropped. When allies stop talking, count them as moving. Track 3. The Cabinet Clock. Every agency head whose department is covered by Exhibit A's suspension of contracting authority is now in a legally impossible position. If they follow a presidential directive that falls within the suspended authorities, they are personally in contempt of a federal court order. If they refuse to follow a presidential directive, they face termination. That choice, between personal legal liability and employment, is landing on the desks of cabinet secretaries right now. The Attorney General faces the sharpest version of this problem. Legally obligated to enforce Whitfield's order. Politically accountable to the president the order runs against. There is no neutral position available. Every hour of inaction is itself a choice with legal consequences. All three clocks expire within the same 72-hour window. Friday, 10:17 a.m. Eastern. That's where all three tracks converge. Part 10. The three scenarios. Watch the signals. There are three realistic paths from here to Friday morning. Scenario 1. Compliance. Calvert's team produces the documents before the 72-hour window closes. Probability, roughly 30%. The signal to watch, Trump's public statements shifting from constitutional defiance language to working through proper legal channels language. If the attacks on Whitfield personally stop and the rhetoric moves to process, compliance is being negotiated behind the scenes. Scenario 2. Supreme Court intervention. Calvert files an emergency application directly to the Supreme Court, bypassing normal appellate procedure using a mechanism called a circuit justice application, and a single justice issues a temporary administrative stay while the full court decides whether to take the case. Probability, roughly 35%. The signal Calvert files in the next 18 hours. If no Supreme Court filing appears by Wednesday evening, this path is closing. Scenario 3. Open defiance. The window expires. The sealed enforcement orders activate. The administration refuses to recognize the parallel enforcement mechanisms. Full institutional confrontation. Probability, roughly 35%. The signal. Escalating public rhetoric. No Supreme Court filing. No document production. And silence from cabinet members who would be required to participate in compliance. Watch which signal appears first. Because the signal that appears first tells you which path Calvert's team has actually chosen, regardless of what the public statements say. Where the clock stands Tuesday, 10:17 a.m. Order signed and filed. 72-hour compliance window begins. Self-executing enforcement provisions activated on a timer. Tuesday, 10:23 a.m. White House public statement released. Pre-written, 6 minutes after filing. Tuesday, 10:44 a.m. through 11:17 a.m. 3 emergency stay motions filed, all pending, no rulings yet. Tuesday, 2 p.m., House Judiciary Committee announces Thursday impeachment vote. Wednesday, appellate court expected to rule on the 3 emergency stay motions. Based on the existing record, rejection is the anticipated outcome. If granted, the compliance window pauses. If denied, the clock continues. Thursday, 2 p.m., House Judiciary Committee impeachment vote. Friday, 10:17 a.m., compliance window expires. Self-executing enforcement provisions activate automatically if no documents produced. What remains unknown as of this writing? Whether Calvert files a Supreme Court emergency application before Wednesday midnight. That filing, or its absence, is the most important data point in the next 36 hours. Also unknown, how the Attorney General responds if Friday arrives without compliance and the parallel enforcement mechanisms activate. Every public statement from that office has been silence. Silence is a position. It just hasn't been forced into the open yet. The 72-hour clock is running right now. Not slowing, not pausing for appeals, not waiting for congressional votes or cabinet deliberations, or Supreme Court conference schedules. Running. And when it expires Friday morning, what happens next will answer a question the framers of the Constitution debated in 1787 and never fully resolved. What happens to a constitutional system when one branch decides the other branch's authority simply doesn't apply to it? The answer is being written in real time. Subscribe, turn on notifications. Because when Wednesday's appellate ruling drops, and when Calvert either files at the Supreme Court or doesn't, you're going to need someone who has read every page of every filing to tell you what it actually means. Not the headline, not the spin. The document. The clock says 72 hours. We find out Friday.